Madam, there is a question from Mr. Nitya Kumar, Palgiri Nitya Kumar. It is regarding the way softwares are protected. Is it uniform across the globe? Like in one country, software is protected, in another country, software is protected under patent, in one country, it is protected under copyright.
Thank you for that question. Now, globally, every country which is a party to WTO undoubtedly has to protect computer program within copyright. So that is a mandate of WTO. So every country who is a WTO member gives copyright protection. To what extent patent protection is available differs from country to country. So that is the confusion I was telling you regarding India. It is available in certain situations. In US also it's available. In EU also it's available. So software patents are a reality. But there is no guarantee that it is available everywhere, because the international mandate is only to protect it under copyright regime. So globally, yes, you have copyright. But whether you have patent or not depends on each country.
Next question is also from Mr. Nitya Kumar. Is there any instance where a compulsory license was obtained for software?
Not in India. If you protect it under copyright, the instances of compulsory license are very, very limited. The instances in which you can invoke compulsory license are also very, very limited. The reason is copyright provides quite a lot of users right under 52, or what you call as non-infringing activities under 52. So a lot of personal use can be done under that. So once personal use is removed, then the question is whether you want to do it professionally or commercially. That the law always doesn't permit unless and until there are specific situations. So invoking compulsory license under copyright is pretty hard. There are very few instances recognized where compulsory license can be governed. And compulsory license in copyright has not been issued to computer program to my knowledge. Coming to patent, in software patent, in India we have not seen any compulsory license on software. In fact, in India we have seen only one compulsory license, that is pharma related. So other than that, compulsory license have not been invoked as a mechanism, probably because there is no problem of accessing software. Only if there is a shortage in access, if you have a problem with access, the law will come out with mechanisms like compulsory license. If you are infringing left and right, there is no problem with access. So the state will not invoke mechanisms like compulsory license. So that is something that you see with computer program. I have not seen compulsory license being issued, neither under copyright or under patent regime. Yes.
The next question is, in case a software company acquires another software company, will the ownership of software be changed to a new company?
It depends on how if it is a merger, it becomes a third company. So keep in mind that computer software is just another form of property. It's intellectual property, it's a form of property. So computer programs are also a form of property. So when I am buying another entity, I will attach myself with all its property. So in the documentation, in the transfer of ownership, all its tangible and intangible assets would be shifting to me. The ownership of all tangible and intangible assets would be shifting to me. So obviously, if I am the purchaser, I become the owner of all intellectual assets, including computer programs. So if there is a registration, for example, in case of trademark, and if it is registered, I might want to inform the registry that there is a change in ownership. If not, there is no requirement for that also. So yes, when ownership changes, ownership over computer programs also becomes either of the purchaser, or if it is a merger, the new entity that came into existence.
Madam, if a programmer who is under employment with a company develops a software which is not part of his work, who will be the owner of his software intellectual property rights?
Okay. Now, if you are creating a software which your employer has not given you, but if you have used the resources of the employer, for example, you were sitting in the office and doing this work, still the employer might have a say over it. But if it at your leisure time, at your home, you are sitting and creating software which has nothing to do with your job, it belongs to you. It doesn't go to the employer. It's only if the employer has assigned it to you, or if you have used the employer's facility in the creation, does the employer has a right. So it's the same with us academics. When we set question papers, it belongs to the university because we are employees of the university. But the research articles we write as part of our study is ours. So that's the distinction you make.
Next question is from one Mr. Aditya Kumar. What will be protected when we patent a software? And also, we are not needed to register for copyright protection in such a situation.
When you are patenting, if you have a machine and the software is machine attached, your patent is for the machine. So you get rights over the machine and you can stop third parties from making, manufacturing, selling the machine, etc. So with machine it's very clear. But with a software which is not linked to a machine, the kind of what we saw being granted in 2020, that is for the software alone. So it's actually a process. You don't have a product at the end. It's a process, and the process is written in codes. So it's for that process and those codes that you get. And the question also remains as to when you are patenting, you have to disclose. So is there the requirement to submit the program per se to the patent office is also a very legitimate question. But then you are getting for that process. And when you look into patent law, there is something called equivalence also. So if I write the program in Java, can you write the same program in C? That cannot be done in a patent because I would have a process, it's just written in a different language. That is the understanding. So when it is a software patent, it's basically the process of how it is being done.
Next question is from Manas Mishra. What are the procedures to deal with infringement of computer programs? What are the universal procedures for protection of computer programs?
Now, if you are looking into infringement, there is no question of universal. Every country protects its. Every country would have its own law to protect IP. So in India also, computer program, if it is being violated, if you have if you are claiming a copyright, you have to invoke the procedures under the Copyright Act. The Copyright Act gives you both civil and criminal remedies. So if you are invoking the civil remedy, you need to find a lawyer and send a notice to the other party and initiate a civil proceeding in the district court. If you are looking out for a criminal remedy, you have to put up an FIR with the police and initiate the criminal actions. If your software has a patent and you are looking for a patent remedy, patent law is only civil, which means again you have to contact a lawyer and then send notice to the other party saying that my patent is being infringed. And again, patent infringement also you go to the district court. Now it's actually the commercial courts that has the jurisdiction. And particularly if it is your patent, like think I am the patentee and I am sending a notice against you, and you have a counterclaim. You are saying that my patent is invalid. Then the matter goes to the High Court. The district courts do not have the jurisdiction. And so the matter goes to the High Court. So it's the normal civil and criminal procedures of the country that apply as far as infringement of the rights is concerned. It's CPSE, CRPC and evidence law that apply.
Next question is from one Satyan. Apart from the whole software, can certain codes within a software be patented by the developer? Like if there is a bug in a software and a developer has developed a certain code to remove or overcome the bug, then can such codes be patented?
Now, code alone getting patent would be a very, very minimal situation because you are actually trying to do only a particular part of it, that code alone to remove the bug. But then the way the systems are working, I will never say no, it is not possible. The code alone might be able to, provided it gives in a huge technical effect, like the 2020 judgment, which was saying that when you are able to do a web search much faster with a minimal bandwidth. That doesn't call in for any kind of software, it's just any kind of hardware. That is just a huge technological boom. Similarly, if it is a bug that you are able to remove and bringing quite a huge technological change in the technological language, yes, you might end up with a patent too. So I will never say a no to it, but then it's totally a flux. If you are a person who is actually doing it, the best way to do is try to put up a patent application and see the response of the patent office. That's something I would prefer from a patent student point of view. And for individual persons to put up patent, the cost today is very low. We have of identifying, and because we want to promote startups and individuals from promote them to patent, the fees is comparatively lower. So it will be a good case study if you have such a person in your knowledge to try and see if patents can actually be governed by the Indian Patent Office.
Yes, ma'am. Last question, ma'am, from Mr. Amit Kumar. Are there any potential career prospects for candidate who is software engineer and law graduate in the field of patent and copyright?
If you are looking for government kind of employment, you are a law graduate, obviously you have a niche in practicing law because you understand technology. Quite a lot of us do not understand technology, so we have a what you call a disadvantage on that. But then again, the problem is a lot of technology-based cases needs to come up. But then otherwise also a person who has this interdisciplinary knowledge of technology and law always have a scope in patent regime. To act as a patent agent, you require a science degree. To become a successful patent practitioner, you require a science degree because you need to understand how the technology works. So it's not particularly your computer program knowledge, it's basically your science knowledge of appreciating how things work, which basically lawyers don't have, would provide you a niche, an edge. Of course, that is there.
Thank you so much, ma'am, for patiently answering all the queries. Now I request the chair, Professor G.B. Reddy, sir, to please continue the proceedings.
Thank you so much, ma'am. In fact, it has been quite a learning experience, and right from the conceptual understanding of the software and computer program till the latest developments in the field, starting with the US decisions, then the Indian decisions, including Farid Alani's case. I think all the participants have got immensely benefited by attending your enlightened lecture, and I'm very sure that this is one area which might require even one more class also. And you have been in fact so passionate that you continued for almost 1.5 hours continuously. So that shows your in fact deeper understanding of the subject and the passion to share your knowledge with all the participants. Thank you so much on behalf of DPIIT Chair and on my personal behalf. And I hope that in future also you would be obliging us on many more occasions, because IPR is one such area where we require constant sharing of this knowledge. And thank you so much.